How are you doing?
Doing all right.
Great.
So I'm just going to read.
We get CME for this?
Yes, you do. You have to fill out your evaluation. You can take that. So I'm just going to read the announcement sheet, but can you start? Oh, you already did. Okay. Standing. So just our quick disclosures. So do not forget to sign in. Everyone, please fill out an evaluation form, especially those requesting to receive CME credit. So today's lecture is on EMTALA basics for the medical staff, and it will be given by Mike Gawley, Esquire, from Nossaman Law Firm. And today's CME activity is not supported by any commercial interest. And as part of the commercial guidelines, we are required to disclose if speakers have any affiliations of financial arrangements with any corporate organization relating to the presentation. Speaker has nothing to disclose. So that's it. So thank you, Mike.
Thank you so much. First, I want to thank the medical staff for having me present today. Before we dive into EMTALA, I want to give you a bit of background on my work. I've been a healthcare attorney for about a decade, specializing in representing medical groups and medical staffs. So I spent quite a bit of time advising providers on a number of areas, and EMTALA is a really key component of that. I also appreciate that spending your lunchtime listening to an attorney is maybe not the first thing you'd want to do. So I'm going to try to keep this as human as possible. For the roadmap of our presentation, there are 5 big buckets that we're going to cover. The first is an overview of what exactly EMTALA is, what the law is. The second is who does EMTALA apply to? Third is going to be when does it apply? What triggers its application? And then the bulk of the presentation is going to be focused on what EMTALA requires, what it actually says you have to do. And then finally, everyone's favorite topic, enforcement of the law. How is it enforced? What happens if you don't do what EMTALA says you have to do? And that's kind of a quick rundown of what I hope to cover here today. EMTALA is a federal law. It's the Emergency Medical Treatment and Active Labor Act, and it really requires 2 basic things. Hospitals need to screen individuals for emergency medical conditions, and they need to either stabilize or transfer those patients if they have emergency medical conditions. Most of what we talk about here is going to be federal law. There is a California state corollary that has a few distinctions that we'll talk about. But again, for the most part, we're talking about federal law here. Now,
and Mike, are you going to share your screen? Sorry.
Oh, has it not been shared?
No.
Oh my goodness.
It's okay.
Okay, well.
There you go.
Thank you, Liz. I assure you the first 3 slides had all kinds of fantastic animations and fireworks. But in the interest of time, we'll just keep moving forward. Thanks for that, Liz. Who does EMTALA apply to? It applies to hospitals with dedicated emergency departments. So it applies to the facility as an entity. It also applies to physicians who are responsible for evaluating, treating, or transferring patients in the emergency department. And an important part of this is those responsibilities, those obligations under EMTALA also apply to on-call physicians. We'll get into a lot of the contours of that because that's an area that comes up repeatedly, but know that EMTALA applies both to the facility and the individual doctors working. Now, when does EMTALA apply? What triggers its application? And that's when an individual presents to the emergency room and either requests treatment or a prudent layperson would look at the patient and say that person needs an examination. That prudent layperson standard, it's not a clinical standard. It is a reasonable person standard. So it's not whether a physician would think that person needs treatment. It's whether a layperson would think that. And I think you'll see a theme throughout this presentation that EMTALA does its best to define and provide boundaries for clinical issues. It's always a little dangerous when attorneys try to legislate clinical issues, but you'll see that I think EMTALA does a decent job of providing general guidelines in that area without being too limiting. So what does it mean for an individual to present to an emergency room for the purposes of EMTALA? The easy one is if they walk through the doors of the emergency room or the emergency department. They come in, they say, I need an examination. That's an easy one, and EMTALA is going to govern that. There's also detailed regulations about what happens when a patient is on hospital grounds, but not actually in the emergency room. And what the regulators have done is they've said that any patient that comes to the hospital property other than the emergency room is going to be deemed as presenting to the emergency room. And they've included a very helpful objective 250-yard radius of the main buildings as the boundary. EMTALA is also going to apply if the patient's in an ambulance that is either owned by the hospital and on its way to the emergency room, or not owned by the hospital but on hospital property. So if a patient is in any one of these situations, the law is going to say they presented to the emergency room. One of the areas that is quickly developing is whether EMTALA applies to urgent care centers. This is an area where CMS, the federal regulators who enforce EMTALA, have rejected a hardline rule. They're not going to say that it does apply or it doesn't apply. What they do is they look to the specific surgery center urgent care center, and see whether they hold themselves out to the public as a place where you can get emergency treatment. And this makes some sense that if you're going to hold yourself out as a substitute or a complement to emergency care, you should be subject to the same rules. I took a look at the urgent care center that Adventist has in Moore Park, and I think that it would tick the boxes for EMTALA applying. The website says that we offer the same quality of care that you'd get in an ER, and it asks whether the patient has a minor emergency or illness that needs treatment right now. Those are the exact kinds of things that regulators are going to look at to see whether EMTALA applies. So if you're at an urgent care center and you're not sure whether you're required to provide an examination or stabilizing treatment, it's best to err on the side of doing it. So the next slide, this one, is actually an area where the regulators did draw a hard line. EMTALA does not apply to existing patients of the hospital. This means that if a patient has been admitted for inpatient treatment, EMTALA is not going to apply to them. Also, if you're at the hospital for outpatient treatment for something other than an emergency, EMTALA is not going to apply there. And this is true even if the patient develops an emergency condition after coming to the hospital. So if they're an existing patient, EMTALA is not going to apply. And there's a few reasons for that. The first one is EMTALA was not designed to address situations where there is an existing patient-physician relationship. There are a lot of good rules, ethical rules, and laws that govern that relationship. And EMTALA is not designed for that. It's designed to create obligations where that relationship hasn't been formed yet. The second reason is sort of an offshoot of the first. Medicare conditions of participation already have a bunch of requirements for what doctors have to do when they treat patients that have been admitted. And then third, and this is the one that the lawyers get excited about, it creates an unambiguous bright line. It makes it really easy to create a boundary and say these patients are not subject to EMTALA and these ones are. So that's kind of the background framework for EMTALA, what it is, when it's going to apply. And now we get into the meat of the law, which is what does it actually require hospitals and physicians to do? And that can really be broken down into two key points. The first thing that has to be done is you have to perform a medical screening exam on anyone coming to the emergency department seeking care. We'll get into what that looks like and what a screening exam entails in just a minute. The second aspect, or the second requirement, is if after performing the screening exam, the physician determines that the patient has an emergency medical condition, you've got to treat the patient until they're stable or transfer the patient to a facility who can treat the patient. We'll get into that in some detail. A key component of this law is that hospitals and physicians have to do this. They have to screen patients and provide stabilizing treatment or transfer them regardless of the patient's ability to pay. Physicians are not allowed to inquire about insurance status. They can't delay an exam or treatment based on methods of payment or insurance coverage. It's a no-no. The regulators and and Congress did not want financial considerations to come into play when providing stabilizing care for emergency medical condition. So that's a key part of the law. This next slide is a oversimplified flow chart for how this process works. You always start with a medical screening exam, and if the patient has no emergency medical condition, you can transfer him, you can discharge, EMTALA obligations end. If the medical screening exam shows that a patient does have an emergency medical condition, your options are to stabilize the patient or to transfer the patient to another facility. I want to include a brief aside here on the medical screening exam portion of this. One area that comes up quite a bit in EMTALA enforcement is what happens if a patient presents to an emergency room and leaves before the facility has had an opportunity to provide a screening exam. They show up and the wait's too long and they end up leaving before they're seen. Or they show up and then they start feeling better and the patient. You might think that if the patient voluntarily leaves, EMTALA obligations stop. That's not the case. If a patient shows up for a medical screening exam and they are not provided one, that can be an EMTALA violation. There's a lot of detail that goes into that analysis of whether an EMTALA violation has occurred, but to the extent that folks are coming to the emergency department and not being seen, that's something that should be addressed. And if a patient does end up leaving, the reasons for the patient leaving, either because the wait was too long or they felt better, should be documented in the chart, and reasonable effort should be made to provide a medical screening exam for them. So this is what I was talking about earlier when regulators try to dip their toes into clinical waters. The law actually defines what an emergency medical condition is for the purposes of EMTALA. And what it says is there's going to be an emergency medical condition when the absence of immediate medical attention could result in any of these four: serious impairment to bodily function, serious dysfunction of a part of a body, severe pain. That's one we see quite a bit. Severe pain being an emergency medical condition. And then this last one really pertains to pregnant women, placing the health of a person or unborn child in serious jeopardy. Remember, EMTALA applies to people in active labor as well. That's considered an emergency condition. So if a physician determines that there's no emergency medical condition after that initial screening exam, the patient can be discharged and EMTALA ends. If, on the other hand, after the screening exam, the physician determines that there is an emergency medical condition, the first thing they've got to do is try to stabilize the patient. And there's an important qualifier to this. Stabilizing treatment has to be performed within the hospital's capability. The federal regulators recognize that not all hospitals are equal. They don't have the same equipment, they don't have the same staff, they don't have the same resources, and they're not going to require a big research institution in Los Angeles to provide the same level of stabilizing treatment as a small rural hospital in far northern California. The general rule is if your hospital can do it, you should do it. And again, there's a clinical definition here in the law. They define stabilizing treatment as such care as necessary to assure within reasonable medical probability that no material deterioration of the condition is likely to result from or occur during transit from the facility. You don't have to cure the patient, you don't have to fix everything, but you got to make sure they're in a place where they're stable. And for pregnant women, this stabilizing treatment includes delivery of the child and the placenta. Now, this next section is going to apply to the non-emergency physicians on the medical staff, and that's when they're on call. EMTALA requires there to be on-call coverage. Again, they've included a qualifier that on-call coverage has to be provided in accordance with the resources of the hospital. An important part of this law is that if you are listed as the on-call physician for a particular specialty, and you are required to come in person to the emergency room when it's medically necessary to treat the patient. And who gets to make that determination? The emergency physician on site. So if you are on call and you get a call from someone in the emergency room that says, I need you to come in to treat this patient, you've got to go in. You can't do a televisit, you can't do it by text, you can't send someone else. The obligation runs to the individual physician, and if the emergency physician makes the call that someone on call needs to come in, they've got to come in. Knowing that this is a tough issue for hospitals and medical staffs, the regulators do offer some flexibility for hospitals to meet their on-call obligations. They allow on-call physicians to schedule elective surgeries during the time they're on call. They also permit physicians to have simultaneous on-call duties, so you can be on call at more than one place at once. And they've created a kind of agreement that facilities can enter into called formal community call plans. Sometimes the law calls them call sharing arrangements. And the idea is if you have multiple hospitals in the same area, rather than requiring each hospital to use their physicians to staff their call, you could theoretically get sharing amongst the physicians, and it would ease the burden on each individual hospital. This next slide has a very detailed list of all the things that call sharing arrangement has to include. But I include this here just to show you the level of detail that the regulators went into on this issue. As a practical matter, these don't exist. I and my partners have tried to find copies or examples of these kinds of arrangements, or multiple facilities are sharing physicians for their call roster. We've looked on the internet. We've done all kinds of research into advocacy groups. We've talked to clients. We've talked to other attorneys, other healthcare attorneys. I haven't met anyone who's actually seen one of these in practice, and that's because facilities generally don't want to share physicians in that way, and physicians typically don't want to practice at facilities where they may not be familiar with the staff or the resources. If anyone has heard or knows of a call sharing arrangement being put into place, I would be very eager to see it. But again, I think this area is a bit more where lawyers come up with a solution that makes sense on paper but doesn't work in practice. Earlier, I mentioned that California has a corollary to EMTALA, and one of the small distinctions that California makes is in what call coverage is required. California requires experienced physicians in specialized categories to be available in-house 24 hours a day. Rather than the federal law, which just says you've got to provide call coverage for your facility based on your resources, California actually requires certain specialties to be on call 24/7. And those specialties are going to be I think there are 5 or 6 specialties that always have to be on call, things like general surgery. But there are additional specialties that are required to be on call based on the hospital's licensure. If there are certain areas that the hospital is licensed to provide services in, they've got to provide call for that area. So there's a bit more guidance from California than there is from the federal regulations in this area. And state law, just like the federal law, recognizes a call sharing arrangement as satisfying the obligation. Again, haven't seen an example of that, but it's a theoretical possibility. Something that I think comes up a lot for individual physicians is compensation for call. EMTALA doesn't require, but also doesn't prohibit payments to incentivize physicians to be on call. The regulators recognize that there often needs to be an incentive to get physicians to be on call. And the way this usually works is physicians are either paid a stipend or the hospital provides a guaranteed floor of compensation. The law says that's okay. Presentation on the acceptable structures for call payments could be its own presentation. It's outside the scope here, but know that these kinds of payment schemes do implicate fraud and abuse laws, and so they have to be carefully structured, and you wouldn't want it to be put together haphazardly. So that section was dedicated to providing stabilizing treatment, being on call, doing what you can to try to stabilize the emergency medical condition. Now, what happens if a hospital and its physicians have tried to stabilize the patient, but it's just out of their capabilities? They don't have the resources, they don't have the staffing, whatever it is, they don't have the equipment. Then what the law says is you've got to seek a transfer. And there are 2 ways that a transfer can be initiated. One, patient requests a transfer. Patient says, I want to go to this other hospital. That can start the process. The other way the transfer process can start is if a physician certifies that the benefits from the transfer outweigh the risks of transferring a patient. Remember, this patient who's being transferred still is suffering from an emergency medical condition. So there is going to be some risk in the transfer, but the law says that a physician got to balance that, and if it's better to transfer, you transfer them. For the patient transfer requests, there are some requirements. It's got to be in writing and it's got to be signed by the patient. You've got to contain a brief statement of the hospital's EMTALA obligations. There has to be a reason for the transfer. You have to describe the benefits and the risks, and that you discuss them with the patient. And then you take that writing signed by the patient, it's usually a template form, and you file it in the patient's medical records, and you also forward a copy to the hospital that's receiving the patient. Now, physician certified transfers, which are the ones that are most common when the physician determines that a transfer has to take place, also have requirements. You got to state the reasons for the transfer. And as part of that, you've got to include a summary of why it's in the best interest of the patient, why the benefits outweigh the risk. This next bullet is something that regulators do enforce. It's got to be timed and dated closely to the time and date of the transfer. You can't backdate it. They don't want you completing this 3 or 4 days down the road. They want your fresh recollection, so do it as quickly as you can. And then again, file it in the patient's medical records, forward a copy along to the receiving hospital. This next slide includes a number of ways that physicians certified transfers can violate EMTALA. These are mistakes that physicians make sometimes. Failing to sign the form. Again, seems like a more administrative than substantive, but it's a big deal, and CMS cares about that. The failure by the physician to deliberate and weigh the medical risks before signing the certification. They really want you to think about it and come to a reasoned decision. Reliance by the physician on an improper consideration is a significant factor. That would include the patient's ability to pay, your standard anti-discrimination being part of a protected class. Anything that's not clinically related could be an improper consideration. And then if you sign the certification, even though the medical risks outweigh the benefits, that's going to be an issue. Now, when is a transfer appropriate? There's sort of a checklist that you go through. And the law says that you've appropriately transferred the patient when you've provided the treatment that you can, and you still haven't been able to stabilize the patient. When the receiving hospital has available space and qualified personnel, and they've agreed to accept the patient. Again, one of the issues that comes up regularly is what happens if a receiving hospital says, we don't agree to take the patient. What the law says is you can't send the patient there. And we'll get into ways to mitigate against that, but making sure that you're clearly communicating with the hospital that's to receive the patient is key. You also got to make sure you send all the medical records related to the emergency medical condition to the receiving hospital, and you've got to use proper personnel and equipment. You can't just put the patient in an Uber and send them on their way. If you satisfy all these requirements, then the EMTALA obligations cease and you've discharged your duty. So if a hospital lacks the capability, this is a sort of follow on from the previous slide. If you can't treat the patient, then you've got to arrange for a transfer. It's key that you first exhaust your capability to stabilize the patient and continue to provide treatment until the transfer is made. Even if you can't reach that stabilization threshold, you've got to continue to provide the treatment you can for as long as you can. Now, this slide summarizes the requirements of a receiving hospital. When does a receiving hospital have to take a patient from another facility? And the patient at the other facility, the transferring hospital, has to have presented to the emergency department. They have to have an emergency medical condition. They have to be not stable. And the transferring hospital has to lack the capability to stabilize the condition. Again, like I said 2 slides ago, the big issue here is whether the receiving hospital agrees to take on the patient. They're supposed to take on the patient if they've got capacity and capability to treat the patient. That in practice doesn't always happen, or sometimes it's hard to verify whether a hospital that you're communicating with to try to transfer a patient to actually has the capability or capacity. And that can really put the original hospital in a bind because they're in a situation where they can't provide treatment to stabilize the patient, and there's not a facility where they can transfer the patient. One way to address that is to have transfer agreements between hospitals. Now, this happens at the hospital administrative level and not at the medical staff level, but it's important to know that these agreements do exist, and they can often be helpful. They are essentially written agreements between 2 hospitals governing how transfers are going to happen, when they're going to happen, who is going to be responsible for communicating these requests, how they're going to be processed. And these can be really helpful in the EMTALA world because they make communications easier, they can reduce costs, and they end up with patients getting the care that they need from facilities that can provide it. One thing that often comes up in EMTALA too is patients refusing treatment. Patients under EMTALA don't have to submit to a medical examination or stabilizing treatment or to a transfer. They can refuse that. And there are certain things that physicians should do when that happens. If a patient refuses any of the required treatment options under EMTALA, the hospital has to explain the risks, explain the benefits of what they're proposing. You have to take all reasonable steps to get something in writing that the patient has refused what you're proposing. You don't have to go through Herculean efforts, but you've got to try to get the patient to sign something acknowledging that they're refusing treatment. And then you've got to describe the offer for treatment, the proposed treatment, the refusal, and the attempts to get something in writing in the medical record. So that's a quick and dirty summary of EMTALA. It ends, your obligations end when the patient is either stabilized, when they're admitted to the hospital, or when they're appropriately transferred to a facility. At that point, EMTALA obligations don't apply and you're back in non-EMTALA world. How is EMTALA enforced? So what happens if the physician or a hospital deviates from the EMTALA rules? Well, there's 2 primary ways that this gets enforced. The first one we're going to talk about is regulatory enforcement. That's government regulators, either with the state or at the federal level, enforcing the law. The other one we'll talk about is private action. That's when patients sue with an EMTALA violation as the underlying theory. So regulatory enforcement is going to be complaint driven. This usually happens when a patient who went to an emergency room seeking treatment complains either to the federal regulators at CMS or California regulators at the Department of Public Health. It's usually patients, but it can be anyone. It can be family members. It could be another hospital. This happens sometimes when there's a communication between a transferring hospital and the receiving hospital. It can also be driven by physicians and staff. There's no limit on who can make a complaint to regulators. Once that complaint is received, the regulators determine if the complaint actually alleges a possible EMTALA violation. If they look at it and say, well, this was not, the patient didn't actually present to an emergency room, or there wasn't an emergency medical condition, they're going to dismiss the complaint, and it's not going to be followed through. But if there is a possibility that it's an EMTALA violation, the regulators are going to perform what's called a complaint survey. And if any of you have been involved in a complaint survey, they're no fun. All the surveys are unannounced. What happens is investigators from the government come on site and they conduct conferences with folks. They review documents, including medical records. They interview people, and it all happens pretty quick. It's usually completed within 5 days after CMS authorizes a complaint survey. The reason they do this is to see if there was a violation in this specific instance that was complained about. The other thing they look for is whether there's a pattern of this kind of violation at the hospital. And then third is to see whether there are policies or processes in place to address these kinds of issues, and so that folks like yourself on the medical staff are aware of your obligations. The other way EMTALA gets enforced is through private rights of action. These are lawsuits that patients file when their rights under EMTALA have been violated. Now, this is good news for the medical staff members. EMTALA claims apply to hospitals. The patients can sue facilities. You can't sue a physician under EMTALA, so that's a good thing for physicians. Usually, EMTALA claims are paired with malpractice actions, malpractice claims against physicians. So as a practical matter, if there's an EMTALA claim brought against the facility, the physicians are likely going to be involved in the malpractice part of the suit. But it's still good to know that if there's an EMTALA claim brought against you for a violation of EMTALA as an individual physician, that's not going to fly. Since we're talking about medical staffs, and I'm addressing a medical staff, I thought it worth including the application of the peer review privilege to EMTALA claims. As all of you know, the work that medical staff peer review committees do is privileged. It's not subject to discovery. The idea is you want physicians to be candid and to be open, and you don't want them to be worried about it being used in a lawsuit. That is true as a general matter, but know that the 1157 protections, which is the California statute that governs the peer review privilege, Evidence Code 1157, those protections are probably not going to protect peer review records in EMTALA suits. And that has to do with where the lawsuits are typically filed. The peer review privilege is going to apply in state courts. It's not always going to apply in federal courts, and it's not going to apply to federal causes of action. So just know that if someone sues under EMTALA in federal court, the peer review privilege is not going to protect medical staff records. That's my quick evidentiary off-ramp for the time being. So we've talked about what EMTALA requires you to do, how it gets enforced. What does that enforcement look like? For purposes of this presentation, the big ones are penalties that regulators impose, and they can be stiff. The federal penalty is $50,000 per violation, and that can apply to individual physicians as well. So, for example, if you're on a call roster and someone from the emergency room calls you and says, I need you to come down, and you don't, you could be exposing yourself to a $50,000 fine. And if you do it over and over again, if there are repeated violations, that can lead to exclusion from Medicare, which is no fun. There are also state penalties that can be imposed by the Department of Public Health, and that can include potentially the closure of the emergency department. They have that ability if there are repeated EMTALA violations. For individual members of the medical staff, you should be aware that if you don't perform on-call responsibilities or comply with the other requirements of EMTALA, it can be considered unprofessional conduct by the medical board, and it could put your license at issue. So the federal and state governments take this very seriously. So it's best to err on the side of over compliance and to try to do your best to follow these basic takeaways. Every patient that presents in an emergency room has to get a medical screening exam. Doesn't matter if they can pay or not pay, you've got to provide a screening exam. If it turns out the patient has an emergency medical condition, you've got to try to stabilize them or you got to transfer. Every hospital has to provide adequate call coverage, and that includes individual physicians can be on the hook for not providing call coverage when they're on the roster. And know that EMTALA is heavily enforced at the federal level and the state level, and it carries significant fine if EMTALA isn't followed. That's my presentation. I really thank you for taking your lunch break to hear me talk about EMTALA. I'm happy to answer any questions that folks have, and I'll turn it back over to Liz in the medical staff.
So I think Dr. Tillis had a question.
Hey, Mike, it's Ira Tillis here again. I have a couple of questions that were, one that was funneled to me and about 20 others of my own. Number one, and this one was sent to me, is there an EMTALA consideration when one hospital sends a patient up to 200 miles away to another hospital, bypassing several other hospitals that may have been able to take the patient? This is a real world sort of situation wherein the Adventist system likes to keep people within the Adventist system and sends patients to sometimes faraway hospitals.
So I think that's a really good question. I think it's going to be a case-by-case determination. If the transfer to a facility that's farther away is medically safe, such that the patient's condition isn't going to deteriorate because of the length of the travel, I think that's going to be okay. Where I think you might run into an EMTALA violation and where regulators might say this is an inappropriate transfer is where the risks of a long travel to a receiving hospital outweigh the benefits of sending them to that hospital. And in that case, you'd want to find a closer facility.
Okay, well, that makes sense to me. I have a few other questions.
Yeah.
What if a patient is brought to the emergency department against his or her will by law enforcement for a medical screening exam? Is there an EMTALA obligation to evaluate this patient kind of against his or her will?
So again, EMTALA has the provision that a patient can refuse a medical screening exam, they can refuse treatment, they can refuse transfers. So in that instance where law enforcement says, you got to evaluate this person, and the person says, I don't want to be evaluated, what you would want to do is ideally get something in writing from the patient saying, we've made a medical screening exam available to you and you're refusing it. That is the way that I would handle it.
Yeah, that makes sense to me too. All right, so you have said that a surgeon, for example, is able to be on call and do an elective surgery as well. Is there an obligation for either the surgeon or somebody else in the operating suite to answer the phone?
Well, yes, the person would have to be available, and there are rules governing how long someone has to respond. It doesn't have to be the surgeon in the OR with their cell phone on them. obviously, but there should be a mechanism to get a message to the surgeon in the OR that their help is being asked for by the emergency department, and that should be arranged beforehand, ideally with the surgeon providing notice to the folks in the OR that they're on call and they might get a call.
Right. Well, in the olden days, we used to say, I'm going in for a surgery. Somebody else hold my pager for me, and that person's on call for that short amount of time. But I agree, they have to answer the phone. Somebody has to answer the phone.
Right.
What if an emergency physician wants to send a patient to a higher level of care, but the specialist at the other hospital says, I don't really think you need to send the patient. You can probably take care of that at your own facility. So that is there an obligation for that other doctor at a higher level care facility to accept the patient? I know that we can obligate a specialist to come into the emergency department of our own facility, but is there any actual obligation for an accepting doctor or a non-accepting doctor at another facility to accept the patient?
Yeah, so this is one of the areas that hospitals run into barriers most frequently, which is communicating with other facilities. There's an argument that the receiving hospital, the specialist at the facility with the higher level of care, doesn't have to take the patient, because one of the requirements for a transfer is that the facility the transferring facility, the one with the patient, has treated the patient within their capability or capacity, and they're unable to stabilize the patient. I think the better view is that the facility with the patient makes that determination, and then the receiving facility, if they've got capacity and capability, should take the patient. So I think there's going to be you're going to get pushback from other facilities. I think that's unfortunately the reality of the situation. But the safer course would be for the receiving end to the receiving facility to take the patient. And if they're unwilling, even though they've got the capability, at that point, your options would be to either file a complaint with CMS that the receiving hospital didn't take the patient, or to try to work out an agreement where, for these kinds of patients, especially if you're seeing them, if it's a particular kind of issue that you don't have the capability to treat, that you'll transfer them. I realize that's might be a dissatisfying answer, but it's an issue that unfortunately doesn't have a satisfying one.
Right. It's only something that can be handled in arrears, not really real time, it sounds like.
Yeah.
And that's unfortunately the situation we're in way too often.
Yeah.
Next question, if you don't mind. Are ambulance services permitted to require patients to sign papers of financial responsibility prior to a transfer?
I want to make sure I understand the question. You're asking it for an ambulance company transferring a patient from one hospital to another, if there's a requirement that the patient sign?
Not if there's a requirement. Is the ambulance service permitted to ask for or to demand a signed paper of responsibility, of accepting responsibility? In other words, that the patient is required to cover the cost of the transfer in an EMTALA situation?
Yeah, so there's two thoughts I have on that. One is there's an argument that EMTALA doesn't apply to ambulances. It applies to hospitals and it applies to physicians. EMTALA can be triggered if a patient's in an ambulance, but that doesn't mean it applies to ambulances. That's the first thought I have. The second one is I'm uncomfortable with a patient's ability to pay being factored into any aspect of the EMTALA process. I think any party, including an ambulance company, runs the risk of either a suit or enforcement action if they condition their services on payment.
I agree, but I think it's a little murky.
Yeah, yeah.
Are specialty hospitals covered under EMTALA? And by that, I mean psych facilities or orthopedic hospitals.
It would only apply if the hospital has a dedicated emergency department. So if you're a psych facility that has an emergency department for psychiatric emergencies, that would apply. If you have a facility that doesn't have a dedicated emergency department, well, let me take that back. If you have a psychiatric facility that specializes in dealing with psychiatric emergencies, I don't think EMTALA would apply if someone came up with, say, a shattered pelvis from a car crash. So I think it's not going to apply to specialty hospitals that don't have general acute care emergency rooms.
Now you're talking about the sending of. What I'm talking about is the accepting of a higher level of care.
Yeah, and the answer is no, because remember, to transfer a patient, they have to have an emergency medical condition. And so EMTALA, again, for both the receiving and the transferring facilities, is only going to apply to hospitals with emergency rooms.
Okay,
now you can voluntarily negotiate the transfer to a specialized facility, but I don't think they're going to run into an EMTALA violation if they say no.
Okay, so a little corollary to that, if you happen to have a psychiatric hospital with an acute psychiatric portion of that hospital that's across the street from the mother hospital that does have an emergency department, and they're under the same leadership, is that then an EMTALA violation if the psych hospital refuses and has the capability and capacity of taking a psychiatric patient who is in a psychiatric emergency?
But are you talking about a transfer from the emergency room to the psychiatric facility across the street, or the other way around?
No, that is the same facility basically. So that's not a problem. I'm referring to a specific case in Ventura, where in say in Simi Valley we don't have a psychiatric facility at our hospital. Is the county facility that has an acute care psychiatric department and is across the street from their main hospital with an emergency department, are they under an EMTALA obligation to accept a high level of care psychiatric emergency?
So again, I want to make sure I understand. So are you talking about when you say they're required to take high level care psychiatric as a receiving hospital from another facility, or someone just walks up?
Receiving hospital from another facility.
Then yes, you look at the facility wide. And so I think if they've got an emergency department and the hospital has a capability to treat the patient, I think they would tick the boxes for a receiving hospital.
So if that psychiatric hospital that does handle psychiatric emergencies is not attached or under the auspices of a hospital with an emergency department, in other words, if that main hospital doesn't exist within 250 yards, they would not be under an EMTALA obligation.
Correct.
Oh man. Okay. Why are HMO hospitals exempted?
They're not.
EMTALA?
They're not.
Okay. And yet we never call them. Okay. Well.
Yeah, I know Kaiser has its own thing, and they can be rather protective, but they're not exempt from EMTALA.
Got to try that someday. Well, that is the end of my 7 questions. I appreciate you handling them in rapid fire fashion.
No worries. Anyone else have questions?
Yeah, can you hear me? This is Mark Russell. I'm an emergency physician.
Yes.
Yeah, I have a question for you. You know, obviously EMTALA was written in the 80s, and it worked well when the medical home was the hospital. But You know, are there any efforts that you're aware of to update it? Because I mean, in general, surgeons have just said, kind of hell with your medical home. We're done operating out of hospitals. We're forming our own surgery centers. And quite frankly, I don't blame them. But I mean, there's specialists that we just simply don't have. Like if you have an ophthalmological emergency in Ventura County, nowhere to go. If you cut off your finger and you need a replant, nowhere to go. I mean, there's essentially specialists we do not have. And I feel like our federal government is 10 to 15 years behind and has really no idea that you can't just mandate care. There's nowhere to send these patients. So are they aware of the kind of growth of surgery centers and that, you know, essentially not forcing specialists to be on call? There's nowhere to send patients, especially who don't have payment options. I mean, you know, we live in a world of moral decay where no one really cares about, you know, doing the right thing. I mean, that may have been the case in the 80s and 90s, but it's gone now. So I know that's quite a rant for you, but are you aware of any efforts to update it? I mean, it's a law for the 80s and 90s, but it doesn't work well anymore.
Yeah, I think you've hit the nail on the head with the law being out of step with the realities of the current healthcare marketplace. And I think you've got surgery centers, you've got urgent care centers too, which the law doesn't quite know what to do with. And unfortunately, the law is slow moving. It doesn't react nearly as quickly as it should to these changing landscapes. And what you kind of have is a system put in place and then tiny changes around the edges to try to account for these things. And in particular, the big issue that you're talking about, the lack of specialists available to provide call coverage. It's something that the law and regulators have tried to nibble away at with half measures. And unfortunately, it's just not there yet. And taking even a further step back from EMTALA, I think you couple the incentive for specialists to practice outside the hospital with the general physician shortage that we've got in California, and it makes it really tough on ER docs like you and hospitals like yours. And so I know this isn't this doesn't solve anything, but I think the your concern about moral decay is I'm glad there are people like you in the ER who don't.
Yeah, appreciate the answer. Thank you.
Anyone else online, or? I think that's it.
All right. And if any of you have follow-up questions, feel free to pass them through Liz, and she'll get them to me, and I'll respond as well. And thank you so much for taking time out of your day to listen to me talk about EMTALA. And if anyone has questions, let me know. And thank you very much.
Thanks a lot, Mike. Really appreciate
Thank
it.
you, Mike.
Thanks, Dr. Tillis.
Thank
Thank
you.
you.
Take care.
Thanks, Dr. Russell.
My only thought is, I know, I should have.
What are you shy?
He's an expert. Yeah, I'm just a visitor.